Hi everyone, my name is Kevin Crowley. I'm an attorney here with the law offices of Lane, Hupp and Crowley, and we're here to talk about possession of drug paraphernalia today. The biggest question is, what is drug paraphernalia? And the answer is really anything, as long as it's used to help grow, manufacture, transport, store, inject, ingest, inhale, or otherwise introduced to the body, then it can be drug paraphernalia. I'm going to talk about a couple of different factors with drug paraphernalia that you might encounter here. Drug paraphernalia is one of the few charges that is often charged as a misdemeanor, even though technically it is a Class 6 felony. All Class 6 felonies can be charged as misdemeanors, or they can be charged as felonies. Now, if they're felonies, they're going to go to the Superior Court of Arizona. If they are misdemeanors, they're going to go to a municipal or justice court. Here in Maricopa County, particularly Scottsdale, you're going to see drug paraphernalia cases where that's the only charge, and those are often filed in the municipal courts rather than in the felony courts. Oftentimes, this can be a benefit to a defendant because they're not being charged with a felony. I had a client who was stopped in Scottsdale. They suspected a DUI. He was not found to be impaired, but they did find a bag that it appeared to previously hold marijuana. There was a smell, there was a residue, maybe a little bit of shake, but not a usable amount. So rather than charging this client with possession of marijuana because there wasn't a usable amount, he was charged solely with drug paraphernalia. That charge went to the municipal court in the city of Scottsdale. Now, if that client had had marijuana on him in his possession, he would have been charged with possession of marijuana too. And in that situation, he would have been charged at the Superior Court for sure. So in our case, though, the officer, I think, felt like he was giving our client a break by only citing him with a misdemeanor into the city of Scottsdale. Now, possession of marijuana, charged as a first-time offense in the Maricopa County Superior Court, I can pretty much tell you you're going to get a diversion program. Well, Scottsdale didn't want to give this client a diversion program, and the reason for that was, well, he's using drugs, and even though we didn't find any drugs, we want him to have a conviction for that. Well, we simply showed them how unfair that was, given that had there been just a tiny bit of marijuana left in the bag, he likely would have gotten diversion. So by using the Superior Court's conclusions and methods, we were able to help our client get out of that charge for drug paraphernalia by getting him into a diversion program. So how do we defend against drug paraphernalia charges? Well, there are two situations when drug paraphernalia is usually charged. Most often, it is charged in conjunction with another drug offense. So if you have marijuana, possession of marijuana, and possession of drug paraphernalia because the marijuana was found in a baggie. Possession of our narcotic drug, cocaine. And possession of paraphernalia because of the rolled up dollar bill that was used to snort it. That dollar bill is now paraphernalia. The other way is when it's charged just by itself, there are no drugs. And as I mentioned when talking about that case, that most often happens when it's charged as a misdemeanor. If it's connected with other charges, what are we going to be looking at? We're going to be looking at constructive versus actual possession. For you to be guilty of drug paraphernalia, you have to actually possess the item. Constructive possession is when an item is, say, in your glove box and you're driving the car. You know it's there, you're constructively possessing it. However, if you are the passenger in that car and you do not know it's there, then that is not in your possession. That drug paraphernalia is not in your possession. So we're going to look into issues like that. We're also going to look into constitutional issues, especially illegal searches, Fourth Amendment issues. Drugs are most often going to be found after the officer searches in conjunction with a traffic stop or perhaps a stop on the street. They search the person, they find it in the pocket, they search the vehicle, they find it in the trunk, whatever it is. Now, did the officer have the legal authority to conduct that search? If not, then the results of that search should be suppressed and the charges would go away. Once more, admissions. People admit to having drugs in their vehicle or in their pocket. You don't have to do that. You have the right to remain silent. Please use it. So if you're charged with possession of drug paraphernalia, please give us a call here at Lane, Hupp and Crowley. We have years of experience working in drug crimes and can help you with possible ways to get out of this. Now, if you've been charged with drug paraphernalia along with another drug, such as narcotic drugs or dangerous drugs, take a look at our pages for those offenses. There'll be more information for you there. Give us a call. We can help you. I'll look forward to hearing from you soon. Thanks.